Hello, students. How are you all? I hope all of you are doing really very well. All of you are, buckled up, all ready, all set for your examination, because now these are the last few days of our exams, right? So today we are again here with the legal updates, and before starting it, I would like to mention here that I hope all of you would have gone through the sample paper of CLAT by now, and you would have realized how important these sessions are. Right, these legal update sessions that I have been taking. All these topics that we have been discussing in these sessions, right? So, how much importance these sessions have with regard to your examination, I hope you would have realized it when you would have gone through all the passages that were there in your sample papers, right? So please do not take legal updates lightly at all, because high chances are there that examiner would be targeting some legal developments for the passage, and surrounding questions can be asked, right? Of course, your concepts would be checked, but concepts would be checked with regard to the topics that are related somewhere to the legal developments that are going on, right? So, on that note, let's start with today's discussion. Starting with the EWS quota, there have been a lot of debate and discussion since quite a long time now on EWS quota, and finally a verdict has come. A case was taken up by the court under the name of Janhit Abhiyan versus Union of India in 2019, and finally Supreme Court has given its verdict by 3:2 ratio, wherein Supreme Court upheld the 10% quota of EWS, right? So economically weaker section is the name of, basically the full name of EWS. Now, the best part here is, the point that has to be noted here, you must have read about reservation and about the 50% limit in the reservation, right? So in Jasani case and these cases, they have spoken about, they have mentioned about 50% limit. But uh, when we talk about EWS quota, it actually is not covered under that ambit of 50%. Okay, it is outside that ambit of 50%. Now, who all are there in the ambit of 50%? They are basically SCs, they are STs, and they are SEBCs. SEBCs means socially and economically backward classes, right? So, this is just the basic of the EWS. Now, talking about the factual part, it was through the 103rd constitutional amendment in 2019 that this provision was taken up through the law. Now, since we are talking about the reservation is enabled, or basically we get these reservation. The root of the reservation is where? In the Constitution, and not just in the Constitution, but in the fundamental rights. Right now, that's why it becomes very, very important to understand this concept from a constitutional perspective, because Constitution becomes very important for your syllabus. Right now, there are two very important articles that covers the area of reservation, especially the EWS reservation. Article 15 and Article 16, both of them basically talks about some kind of equality. Okay, so Article 15 talks about the prohibition of discrimination on 5 grounds, and Article 16 talks about equal opportunity in the employment. Okay, and to prohibit discrimination on 7 grounds. Right now, the uh, the important part here is that Article 15 is focusing on the prohibition of discrimination, but the further parts of it means 15.3, 15.4, 15.5, 15.6, these all articles, these all parts, they are all enabling provisions. Enabling provision means these are the articles that will help the government to execute what is the main subject matter of Article 15. What is the main subject matter of Article 15? Prohibition of discrimination on these 5 grounds. So, in order to enable that, in order to execute that and bring it into functionality, these articles would be required. And these articles contain one provision that talks about EWS also. And hence these provisions are called as enabling provisions, right? So Article 15(6), Clause 6, they talk about EWS reservation as well. And I hope you would have being thorough with your fundamental rights concept. However, Article 15, Clause 3, they talk about special provisions. They give government power to make special provisions, special laws for women and children. And Article 15(4), they give the government right to make special provision for SCs, STs, and SCBCs. Same as with Article 15 clause 5, and Article 15 clause 6 talks about EWS reservation. Now, talking about Article 16, they talk about equality and opportunity in the matters of public employment. Now, here there are 7 grounds. Okay, here there were 5 grounds: religion, race, caste, sex, and place of birth. Here there are 7 grounds: religion, race, caste, sex, descent, place of birth, and residence. All right. Now, this is the main subject matter of Article 16, again followed by certain further provisions, and all of them are enabling provisions. Like Article 16, Clause 6, it was about the EWS reservation into the public employment, and this would also be a part of enabling provision in order to in order to help the government execute the subject matter of the main subject matter, the central subject matter of Article 60. Right now, if you want, you can take a reference to these 2 cases, Indira Sani case and Keshwananda Bharti case, very important ones. I'm sure you would have heard about these cases, and you would have read some snippets about it, about these cases here and there. So yes. Now, since we are in lines of the reservation part, there was another update last month about on the lines of reservation, and that was about the inclusion of a particular community in the ST list. So there is a linguistic minority community, that is Pahadis. So they have been, since a really long time, they have been, conducting protest against government in order to get them included and listed in the STs list. Now, okay, now we read this news, but what is important here is, firstly, this protest was called off. Fine. But what if it would have continued and government would have accepted? Suppose government accepts it and now government wants to put this community in the ST list. Let's suppose that. How will it take place? So again, this also has its backing in constitution, and everything that has its backing in the constitution becomes important for us to understand, right? So there is this Article 342 in the constitution that talks about that, basically is a provision with regard to the inclusion of these inclusion of a community in the ST list. So how does it basically take place? Firstly comes into picture the president. Now, president will be doing the research with regard to the officials and all of that, with the help of the officials, and taking in the consultation of governor. Governor will be taking consultation, research work, and all of that of their particular state. Now, governor will send, or basically, president will have a consultation with the governor. On the consultation of the governor, president will make a list specifying certain tribes that can be deemed to be an ST community in that particular state. So it happens state-wise. Fine. Now, president has that list. On the basis of that list, now Parliament takes up the matter. Now, second picture is of Parliament. Parliament is into the scene. Now, it would be up to Parliament to decide whether to include that community that have been mentioned in the list or to exclude it. Yeah, on the basis of their discussion, and finally they declare it as to which all minority or which all community or which SC, which ST, basically which ST here, which scheduled tribe has to be, enlisted in the list, and they declare it through a notification. Parliament declare it through the notification. Yes. So this is the constitutional backing of the inclusion in the ST list. Now comes the collegium system. Now recently, again, there were there was a criticism basically with regard to the collegium system to make the appointment of judges in the Supreme Court and High Court more transparent, because it is opaque and all of that. So there have been a discussion. Now we need not get into that discussion for our examination. What we need to get into here is again the legality of it. Firstly, what is this collegium system? We referred to it in a few of our previous sessions also. But again, from another perspective, talking about the collegium basically means where, uh, 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 the way through which the High Court judges and Supreme Court judges are appointed, or they are transferred from one High Court to another. Okay? Now, talking about collegium, when we talk about the Supreme Court, okay, for the appointment in the Supreme Court, appointment of a judge in the Supreme Court, 5 members are the part of collegium system. First member would be the head, that is our CJI, of course, and followed by the other 4 members would be 4 senior most judges of the Supreme Court. All right. And same formula has to be applied in the High Court Collegium also. There are High Court Collegium also. But here it is a 3-member body. First would be the Chief Justice of the High Court, and then comes the 2 senior most judges of the court. All right. So this is how a collegium system is formed. But see, these are the appointment of judges, right? High Court and Supreme Court. But they do not originate from Constitution, right? So there have been a lot of to and fro with regard to the appointment of, to and fro with regard to the appointment procedure of appointment of the High Court and Supreme Court judges, because few years back there was this new proposal that was made with regard to NJAC. NJAC means this was proposed that there needs to be a body named NJAC, National Judicial Appointment Commission, and such should be the body who should be responsible for the recruitment and appointment and transfer of judges in High Court and in Supreme Court both. So it was through the amendment of 99th Amendment in 2014. However, at the end of the day, through after a lot of debate, heated discussion, collegium system prevailed in our system, and NJAC was struck down. It was scraped off, right? So that was the case of Supreme Court AOR Association versus another versus Union of India. So actually, when we talk about the appointment of the appointment of judges through collegium system, there have been a lot of debate that has gone through. Okay, by now there have been a lot of debate, and it has been going on since a really long time. So this is not the first time that government is asking the court for the transparency and not to be opaque about the appointment and retirement and all of that. All right, so it has been there since a really long time. So how evolution took place? So there was this first case. There have always been a debate about the term consultation. Okay, now it basically, the law mentions that there has to be a consultation in case of the Chief Justice, for the appointment. Now, there was this case, P. Gupta and others versus Union of India back in 1981. Okay, back then. So then in that case, it was decided that, okay, now when we talk about the Chief Justice of High Court or the Chief Justice of India, both of them have the same importance. So if consultation is taking place with regard to the appointment, both of them should be given the equal importance. Again, the matter came in 1993, wherein AOR Association versus Union of India was taken up, wherein it was decided that no. Now, Chief Justice of India will be having a greater significance in the matter of decision making when it comes to the decision of appointment and transfer of judges. And finally, in 1998, it was clarified that, listen, none of these judgments should be followed, because these are two extreme paths, right? So there was a mid path bole to Buddha path, right? So that was taken up, and that was the case of In re presidential reference case in 1998, means after 5 years of that judgment, wherein it was said that, okay, now CJI takes recommendation in order to basically make the recommendation backed by the consultation from the High Court and Supreme Court judges, right? Now, it was finally decided that if the Chief Justice of India is making certain recommendation about the appointment of the judge, but he or she has not taken up uh, the constitutional process of consultation process of High Court or Supreme Court judges. In such case, such decision recommendation will not be binding on the government. So in order to make it binding for the government, CJI will have to consult the judges, and that is why now we have the collegium system, as we just discussed, 5-member body, 3 members body for Supreme Court and High Court respectively, right? So this is the basic story and background of this case, right? So that would be it for the session, students. Thank you so much and all the very best. If you have any question, if you have anything that you want me to cover, please put it in the comment box. I will get to know what is it that you really want my help in, and I'll see if I can help you with that before your exam, right? So that would be it. Thank you so much, and take very good care of yourself. All the very best. Bye.